again tonight. We have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. We've planned another great and exciting show for you tonight. Tonight we're going to talk about a capital murder. We have in the studio two relatives whose nephew and cousin are charged with capital murder. I also have my co-host, Mr. Ricardo Rodriguez, who is a well-known and well-respected criminal lawyer in the Houston-Harris County community. I'm going to start off by reading the headlines from the Houston Chronicle, just explaining what the public has been told about this capital murder. It says that a man was arrested in a triple killing at a club. The man is charged with capital murder. Additional suspects are being sought. A 24-year-old man has been charged with capital murder in connection with the June 20th, 2012 shooting that killed 3 people and injured 2 others, including local rapper Trey the Truth, after the performer's concert at a Southwest Houston club. Fenichi Uvukanze, 24, was arrested and charged late Tuesday night, said Keisha Smith, the spokesperson for the Houston Police Department. We are looking for other suspects, said the HPD representative. 2 weeks ago, 3 people, Coy Thompson, 23, Erica Rochelle Dotson, 30, and Carlos Durrell Dorsey, 31, were killed when gunfire broke out in a parking lot after Trey the Truth performed at a club at 9850 West Park, which has gone through several name changes recently and was known as both Diamond's Gentlemen's Club, Club Blue, and formerly Scores Cabaret. The rapper, whose legal name is Frazier Thompson III, no relation to Coy Thompson, and 37-year-old Willie Watkins were shot and wounded in the incident. A woman answering the phone at Uvukanze's parents' home in Houston declined comment. Uvukanze has an extensive criminal history, according to the newspaper, that includes a 2008 conviction for a misdemeanor case of possession of marijuana, misdemeanor criminal mischief, and felony possession of controlled substance. So, the records at this time have him shown as a suspect. They say that, this is what the paper is alleging, Uvukanze fled the parking lot of a club at 9850 West Park, which has been known as Diamond's Gentlemen's Club. Days later, an anonymous tipster reported that Uvukanze was the gunman. Witnesses later identified Uvukanze in a photo lineup as the triggerman. The 24-year-old was arrested Tuesday, charged with capital murder in the deaths of Thompson, Erica Rochelle Dixon, and Mr. Dorsey. Trey the Truth, whose real name is Frazier Thompson, and Willie Watkins were wounded. So, we want to talk about this tonight. We want to talk about how this has affected the family, how the process is going, and how the DA's office and the lawyers in a capital murder case begin their investigation. Uvukanze was arrested July the 2nd, 2012. So October the 2nd, 2012, he will be held without bond for 90 days. What's interesting about this capital murder, unlike many capital murders that I've been involved in, is that the police report is not being released. I find that very interesting. I have Ricardo Rodriguez in the studio, and we're going to talk about some of the issues related to this case. Callers, as always, you're welcome to come and voice your opinion. You may call me at 713-807-1794. And I will caution you that the family members in the studio are a little shy. They're a little uncomfortable speaking in front of the camera. And they do have accents, so we'll take it slowly. But they're still a part of our great Harris County community, and they have a voice to be heard. And they have questions that you might have, and if you were caught yourself in a similar situation. So Ricardo has graciously agreed to be here in the studio tonight, and I've caught him off guard. I didn't tell him what the subject was going to be, but we will ad-lib and try to give you advice as we go along. So Ricardo, thank you for agreeing to co-host with me. And let's talk about this. I know you've had an opportunity to look at not the police report, but the news clippings. So let's talk about how capital murder cases are charged and what's usually expected when a capital murder happens. First charge and a person is arrested.
Well, it sounds rather strange to me that you've not been allowed to see the police report. Typically, after 60 days, they should have put something together. And there's where the capital murder investigation begins. You want to read the offense report. You want to see what their witnesses have to say, so you can conduct a thorough investigation. Typically, like I told the family earlier, they have to be very patient. These cases will take a very long period of time to resolve themselves. First and foremost is the next step in the process will be whether or not the DA's office believes that there's enough probable cause to indict this gentleman for capital murder. And then, of course, the process will take the next step, which will be whether or not they think it's a case that warrants the death penalty.
And in your experience as being a lawyer, how long have you been practicing down at the Harris County Courthouse?
Approximately 27 years.
It's a very long time, and you're very well respected, and I think my viewers are lucky to have your point of view tonight.
Well, I'm honored to be here. Thank you, Vivian.
Thank you. So I find it interesting that I have not been able to see the police report. The young man's father is also a lawyer. He has been able to see it, but my first court appearance was today, and there was no file at all. I did go and speak with the DA last week and requested a confidential copy of the report, promised not to share it with anyone else, and I expected to have it. Now, one of the things the district attorney's office has done, before I was hired, but when his father was representing him exclusively, a letter was sent to his father, which is customary to be sent to the lawyer in a capital murder case. And it basically says, it's a standard letter, as the attorney of record in the above styled and numbered cause, I am writing to give you an opportunity to submit any information regarding your client that you believe may impact the district attorney's decision as to the indictment and or disposition of the case. Now let's talk about that statement, Ricardo. Any information that you might think might affect or impact the district attorney's decision. So tell me what information you think a defense lawyer needs to be able to provide any information to the district attorney.
Well, first let me say this, Vivian. I think that that's sufficient expedition on the part of the DA's office. They want to know everything under the guise that if you tell us enough and we feel that there is enough mitigation, guess what? We're not going to seek the death penalty. I believe it's a double-edged sword. It's going to be your call as to whether or not you want to give away all of your mitigation at this point in time. And even if you did, they may still indict him for capital murder. They may still seek the death penalty. So that's going to be a call that you're going to make down the road once you get your mitigation specialist and you determine what is there and what's not there. But those are typical letters that are sent. Obviously, they think they have the witnesses. They have enough information there to get an indictment for capital murder. Then the next step in the process will be, is it a case that warrants the death penalty or not?
That's a great explanation. Thank you. And the next sentence says, if you wish to submit any information that you have regarding your client's innocence, whether or not the district attorney should seek an indictment against your client for capital murder, or whether there is sufficient mitigation against the death penalty, please provide that information to me, the prosecutor, by September 17th, 2012. You may present this information in person, by fax, or by letter. So let's dissect this sentence. If we say hypothetically, we're the defense lawyer in this case, and we want to prove or provide information of innocence or whether or not they should seek the death penalty, what information do we need to have?
Well, I think the September 17th deadline has come and gone.
It's come and gone.
Yeah. But I believe that you bought some time because you've not had access to the offense report.
Right.
And I think that's critical. And it begs the question, what is the prosecutor holding back? Why isn't she willing? Once you sign the confidentiality agreement, as you well know, you can share it with other lawyers that are representing this gentleman. You cannot share it, of course, with the defendant.
Right, but you can share it with other lawyers and your investigator.
Right, exactly. So again, it goes back to getting your mitigation specialist to go over there and to conduct a thorough and extensive interview with your client to see what potentially mitigating might be there. What evidence can I show the prosecutor if I elect to do that? I think you bought yourself some time because you've not had access to their file. And I would just encourage you to just do your job. Continue to talk to your client, visit him regularly in jail, and just encourage him to tell him that it's a long process and to be as patient as he can.
Well, one of the things that I did since I was just hired, I went and spoke with the DA on September 18th. So that's already one day past them wanting the evidence. And his father is his lawyer, and he hadn't prepared any evidence. So, because he's just unsure about what to do. I asked her for more time. Give me 60 more days. You don't even need to indict him yet. Just give me some time to read the report and investigate. I thought we had an agreement on September 18th that she would copy that report and I'd have it at least by the court date today and buy more time with the promise that we will not try to get him out and we will not honor the 90 days in which he can get his bond reduced. I made that promise. So I didn't anticipate today that there would still be a withholding of the DA's police report. Even if they didn't give me a copy, which is Pat Lycos' policy, redacted copy with people's addresses and date of birth and social security numbers deleted and redacted, I still expected actually the DA to do what's usual and customary, to bring a file for me to sign. So let me just tell you one of the reasons why I'm running for judge, and I think things are so nonsensical down at the courthouse, and they're not efficient like it should be. I'm in a hearing in another court today. I'm there for about probably till 10:30. I'm getting called by this court, the 174th, the coordinator, and the prosecutor tell me, come to court, come to court, come to court. Now, mind you, I went on the 18th, which wasn't a court date, and told them that I'm the lawyer. I filled out the request and motion for the offense report. I signed the confidentiality agreement. I was told they didn't want his father to see it. I specifically wrote, I will not give it to his father. And so usually the reports are ready within 48 to 72 hours. So on the 25th, which was yesterday, I'm calling the prosecutor saying, look, are you going to have that report ready for me tomorrow because it's the court date? No, I'm not giving it to you. Okay. So, mind you, what's the purpose of me going to court today? But they're calling me, taking me out of a hearing that I'm having in another court. Come on, we're waiting on you. And so in my mind, because I was an internal auditor for 9 years, I've been a banker, I'm used to things being run efficiently or figuring out ways for things to run more efficiently. I'm wondering, well, why are you calling and bugging me if there's nothing for me there's no police report? So I tell them I have to leave this court. I go to his court. I already know that there's no police report because she told me the day before, but I'm still thinking that she's not giving me the copy of the police report, but I'm still thinking I'm going to see it. There's going to be a file there. So I'm asking her, I'm like, okay, so I'm here. What's the big deal? Well, why am I there today?
Right. Vivian, it begs the question, did she articulate to you the reasons why she didn't bring the file or why she's not willing to show you the file at this point in time?
No, she didn't. No, she didn't. She does not want us to investigate the case, apparently. So if you might notice the letter that I wrote, and we have a call, so caller, I'm going to talk to you, and then I'll continue to talk about this later. Thank you for calling Truth and Justice with Vivian King. Please turn your volume down on your TV and talk directly into the telephone.
Hello there, Miss Vivian King.
Hey, how are you?
It's your biggest fan again.
Thank you, my biggest fan, for watching and calling.
Okay, and hello to your guests in the studio with you.
Okay. We have Pius, Patrick, and famed lawyer Ricardo Rodriguez.
Okay, hello, you guys.
Good evening.
I just want to say thank you for having the show. I learned a whole lot, from watching the show. But what you're talking about tonight is very interesting, and it's kind of hard for somebody to get a fair trial here in Harris County. What do you say?
It can be difficult, and that's one of the reasons why I produced this show, is because I want the public to understand how the process works and how difficult it is to defend someone. I have a young man who I met today and told me that he's innocent. He didn't do it. but I can't even start working on it because it's kind of like a football game is the way I describe it to my clients. When the offense moves, the defense moves. When they move, I move. I don't even know how to move. I don't know what to investigate. I don't know what to do because I don't even know who's accusing him of this murder. All I know is that it was after a party, it's a full parking lot, and there are gunshots going everywhere. And I know that an anonymous tip has been called in to Crime Stoppers, and as Ricardo and I know, that a lot of people call in to get that $5,000, and they didn't see it, but it's just things that they've heard about in the street. And so they usually will hear about something, give someone's name, and then hope that then the police try to make the facts fit that name. But generally, the tipster is not a person that actually saw it, 50-50. And that name will remain anonymous. So it's very difficult. And thank you for watching, Tracy. You know I love you. Thank you for being my biggest fan.
Okay, love you.
Bye-bye. So one of the things that the Constitution requires that criminal lawyers give what we call effective assistance of counsel. We have to perform up to a certain level of competency and proficiency. And one of our duties is to investigate. We are charged with the constitutional responsibility of confronting our clients' accusers on the witness stand. When they raise their right hand and swear to tell the truth, the whole truth, and nothing but the truth, so help you God, we have to confront that. Part of that is investigating. The longer the DA holds out the evidence and the person's name, the harder it is for us to investigate. So talk about that, Ricardo.
Well, that's a primary part of our case. We have a duty to investigate. The last thing you want is a court of criminal appeals to come back and says that you were ineffective, you rendered ineffective assistance because you didn't fail or you failed to investigate. Our duty is to make sure we speak to every possible witness, including those that were at the scene and elsewhere. But it's critical, I think, that the sooner you get started, because as you well know, the passage of time, people tend to forget. And this happened at a nightclub at 3 in the morning, as I understand it. So it's critical, I think, that the sooner you get a copy of the police report, you'll know who the witnesses are, and you'll be able to send your investigator. And in many instances, I know you, the good lawyer that you are, you're going to go in person with the investigator to talk to these people. And more than likely, Vivian, as you all know, they've already reduced their statements to writing. And of course, you're entitled to see those. You're not entitled to a copy of those, but we can make notes from those statements. But you do have a duty. That's what the statute requires. That's what the Constitution requires to render effective assistance of counsel.
Thank you, Ricardo. Yeah. So the DA knows that, and that's why the letter says, if you have any evidence there that you want us to present. And her letter says it, but just think how nonsensical it is. Do it by the 17th, but I'm not going to let you have the tools to do that investigation.
That's pretty much what she's telling you in the letter, and I'm just surprised that she's not closing the file to you. She didn't articulate that to you. She simply said, I didn't bring my file, and I don't have a copy for you today.
And I'm not going to let you see it until after he's indicted. So, but that's also nonsensical. Yeah. You're writing a letter August 13th saying, give me this information by September 17th that might affect the indictment, show his innocence. What can I do to show someone's innocence if I can't know who said he did it? I mean, he was at the club that night. He was there. But maybe the person who identified him, if I saw that person in the police report, we might have information that that person was in jail, or that person couldn't have seen that. We can start talking to other people there to say, did you ever see this person there? Because this person might be lying. So, or this person might be going on hearsay. But I do trust that when the district attorney's office and the police say that there is a witness that saw it, there is one. I mean, we trust that. We don't think that they're lying about that, so I don't want to give that false impression. But there might be a motive to lie. A lot of times the people who call as anonymous tipsters are girlfriends, disgruntled wives, disgruntled girlfriends. A lot of young people have 2 or 3 girlfriends. So a lot of times the people who call in are people who want to get you in trouble. Talk about that, Ricardo.
Well, the article that you just read into the record, so to speak, talks about a throng of people. There are many people out there. It's 3 o'clock in the morning. It just seems to me that the article suggests that there's one or possibly more witnesses that ID'd the defendant in this case. And I think the sooner we know who they are, the sooner you can talk to them, interview them, because you have a duty to do so. Now, A lot of times, these witnesses feel that, well, I'm a witness for the state. I'm not going to talk to you. And how many times have we heard that?
Over and over.
And on many occasions, they'll hang up on us, but we still have to make that effort.
Right.
We need to go out there. We need to contact them. And the sooner we do it, I think it puts us in a position to know what the state's case is.
That's
how am I
absolutely
gonna,
right.
Yes, and how am I going to prepare for this case? But the article seems to suggest that there's one or maybe more that have ID'd them and picked them out of a photo spread, as I understand.
And the article also seems to suggest that there are more than one shooter, because they talk about other suspects. So that means that there are 3 dead bodies. So one of the things I have to look for in the team that I'm assembling is multiple guns, like a 45 and a like a 25. Maybe there are different bullets in people that had to be shot from different weapons. That's another thing that we need to find, because most people are not running around with 2 different kind of weapons in their hands shooting. So that means that would help prove or show that there are multiple shooters. That's one of the things I will do when I look at the autopsy report. And the good thing about our medical examiner's office now, compared to many years ago, is that we can make appointments, we, the defense, can make appointments with the medical examiner's office and actually interview the person who does the autopsy and go through everything, the trajectory, the plausibility, and they're really working hard to be neutral and nonpartisan and not just say what the district attorney's office theory of the case is, but to actually just meet with both sides and try to stay neutral. And I appreciate that new attitude that they have.
And that's a great point, Vivian, because if you'll recall back in the 90s, it almost seemed like the medical examiner was a hired gun for the state.
Exactly. And they got in trouble for that. Talk about that, Ricardo.
Well, let's talk about that. I remember, without mentioning any names, but we know who a particular medical examiner was that would constantly testify for the state. And she had a way about presenting her case that she thought she worked for the county.
Right.
And that she was hired by the state. And on many occasions, I remember trying to remind her that you're not hired by the county. You're here as a neutral, detached medical examiner to tell us what your findings are. But there were many times that you were fighting a brick wall.
Right.
But those times have changed, and thank God that it has. And
but
now
it came because the DNA lab was found cheating, and the medical examiner's office was cheating, because the whistle was blown on these people. It had to be revamped, and procedures had to be written for it to be neutral and not just an arm of the government.
Right. And the beauty is that you can make appointments and they'll welcome you with open arms. You can go down there and even look at the autopsy itself.
Exactly.
But you can talk to these and they'll tell you about trajectory, how the bullet entered, the type of bullet it might have been, what caliber it might have been. These people are phenomenal. They're well trained in their field, and I know that you're going to go down there and try to get as much information as you can from them.
Absolutely. But I think that, and maybe you disagree, but I think that the time to go is after you read the police report, because you want to see if the witness said he was running when he shot him or he was laying down when he shot them. So you want to already kind of have an image in your mind of how this shooting occurred, for me, before I go look at an autopsy and before I see where bullets entered, where they exit. I want to kind of have a visualization so I can either put it to rest or I can add it to my theory of defense or figure out exactly what happened. So those are some of the questions. Now I see Patrick, the cousin to the accused, is writing notes. So Patrick, do you have a question that you might want to add to this conversation?
If I would just add, I want to know exactly why exactly they are not allowed the father of the crime committer to see the reports. They didn't allow you. They didn't allow the father. Do you feel it's right?
I don't feel it's fair. So the question is, now I want you to know that Patrick is visiting from Germany. He speaks 4 languages, Igbo, German, Greek, and English, and he lives in Germany. So bear with him that he can even speak English. So anyway, he doesn't think it's fair that we're not allowed to see the police report. No, I don't think it's fair. I do believe that they're going to eventually give me the police report. I'm a little insecure about whether they're going to give it all to me, because it's just something, it's just highly unusual. I have never had a case that has gone to the grand jury without me never seeing the police report first. Has that ever happened to you, Ricardo?
No, never, never. So I just find it very strange that the prosecutor at this juncture would not allow you to see that. Show me whatever it is. I don't care if it's 2 pages of a police report,
right,
but at least share it with me and let me see if there are different shell cases at the scene that shows multiple shooters.
Right.
Yeah. So I think it's critical. And I agree with you, Vivian. Eventually she's going to let you see the police report, but when and why is she delaying?
And another thing that's suspicious with me and the family, and I can't make them feel better, is that is she hiding something so they can go tell the witnesses something? Because that's what some of the family's concerns are, and I can't reassure them, because prosecutors and their investigators do sometimes tell witnesses, you don't have to talk to them, and they don't. The only time the witnesses have to talk to us is when they're under oath on the witness stand. Right. So everyone has a constitutional right to remain silent and not cooperate unless they've been court ordered and subpoenaed to court to testify under oath. But most people want to tell you exactly what they've told the government. Why would you be biased one way or another? Tell us. Because sometimes when you tell us that you saw it and you can convince us that the crime occurred as the government has alleged, that helps us know that we shouldn't waste a jury's time and go to trial. We should plea bargain then, because we're not going to win. But if I have a client telling me he didn't do it and I can't read the police report, it makes me think that suspicious of the government. What do you have to hide? The truth doesn't change. Right. I mean, if someone saw it, they saw it.
And
nothing changes.
That's right, Vivian. And I certainly hope that law enforcement would not tell these witnesses, don't talk to the defense if they call you. I hope that that's not true, but you and I well know that it's happened in the past.
It has.
And when they hang up on you or tell you I have nothing to say, then there's really nothing you can do at that point. Just log it in, make a notation of it, and like you said very eloquently earlier, we get to see them in court. Right. We get to cross-examine their perceptions and their testimony in court. So hopefully law enforcement, they speak to them first, and that's typical in every case, whether it's capital or any other case. But you would hope that they would be open to speaking to us too, because we certainly want to talk to them, because it may make the difference whether or not it could generate a plea. You're absolutely right.
Right, because what the public needs to know is at least 90% of all cases are worked out in a plea bargain. But it's because we've investigated it, because remember, police officers are stressed, they're watching their own safety, they're trying to come to a scene and assess what happened, and so they're hearing bits and pieces of what happened. So when they put this police report together, it's all hearsay and it's all uncorroborated. Usually it's just a bunch of hearsay of what people have said. A lot of people who have information, especially if they are gangbangers, do you think they're going to stay and talk to the police? Mm-hmm. No, they're going to leave. And so a lot of times the bits and pieces the police collected are fourth and fifth hand information, and we all know from our exercises in elementary school, once you whisper and tell one person something, and you whisper and tell that one, and you whisper it, it comes out to be something totally different from what the first whisperer said. So that's why we have to investigate it, and we have to watch, and as the public, we have to make sure that the government or the prosecutors don't get to stick to something that was said that night, because you don't even know if they talked to the right people that night. You don't even know if the investigation was complete on their part. So holding him without bond doesn't seem to be fair, and they're trying to justify continuing to hold him until they have information. So Pius, I see that you've been writing some questions. Would you like to share a question about your nephew's case?
Yeah, actually, the family was very much concerned about the way and the manner this case is being handled. Of course, United States of America is regarded as the leaders of the world, and they should lead by example. We are very much concerned that a fair hearing is not given to this matter. Take, for instance, the way they said from the police that there were two shooters in this matter, and the second shooter have not been found. They went and dumped this person in the cell. They put him in the jail for there. Then we have hired a lawyer who will defend us, but they have not given us the material to defend the matter. It's not what I expected from this developed country.
So let me stop you there, because some of my listeners might not understand you. I understand you. So what his concern is that he's from Nigeria, is that correct?
Exactly.
And he's been here about 5 years, and he expected more from the leader of the United States. He thinks the United States is a leader, it's a democracy. He expected to be treated fairly, and he's disappointed with the way the criminal justice system is working in Harris County. Do you want to speak to that, Ricardo?
Yes, Vivian. What I want to tell Pius is that sometimes you have to be patient. The wheels of justice sometimes turn very slowly in this country. Specifically in a case like this, capital murder, it's going to take a long time to resolve, and you're just going to have to be very, very patient. I know that there's cause for concern at this point in time. Why is Ms. King not being allowed to see the police report? Whatever it is, show it to me. I would hope and pray that they're not withholding something from her, and I don't think that's the case, and I'm not going to make that allegation at all. I think what they're doing is putting the case together to make sure they have a rock-solid case, if that's what it comes down to. So I would just suggest to Patrick and Pius to be very patient and let the course of justice take its natural course. And let me just say this. Criminal defense attorneys are the only ones that stand between a wrongful conviction, truth, and justice. So we play a very important part in the criminal justice system. So I would just tell you to listen to the lawyer, and truth will prevail.
And I agree with Ricardo on that, and thank you for saying that so eloquently. The right thing will happen eventually. It will take a long time. And one of the things I think people are real frustrated about the system is that it takes so long. You have this family member who's been in jail for 90 days, trapped like an animal, on lockdown, but yet nobody knows the details of why he's here. He's hearing all of these rumors and innuendos, but yet you're just trapped in limbo. And God forbid, he's innocent as he says he is, he's just trapped. And no one can work in his defense, in his behalf. And people are sometimes afraid to tell the truth because that's not what the government wants, and they're afraid that they'll be after them. Now, there have been some allegations that someone has ended up dead in this case, and that might be a reason why they don't want me to have the police report. But if they ended up dead, my client was in jail during that time. So I don't know how that would have happened. Apparently, there is a killer out there because 3 people were killed at the scene and 2 people were wounded. So that almost seems to me that you have the wrong shooter. If someone else that was at that scene has ended up dead, since this young man has been in jail since July the 2nd, then it seems to me that the police would be worried that they have the wrong person in jail, and not that he had something to do with it. He's not some big kingpin. He's just a 24-year-old young man. So it's not like he has the power to put a hit out on somebody. If he did, he wouldn't be the person who did the shooting in the parking lot, as the government thinks, right? I mean, if you can put hits out on people, why would you ever dirty your hands? So it's a lot of crazy things going on in this case. But hopefully, if parents are watching, young people are watching, you realize that you want to stay away from trouble, because it's easy to get in trouble by association or otherwise, or because of a hothead or a temper or road rage, but it's very difficult to get out. Here, now we have a young man in jail 90 days, and he has not, his lawyer, his father, his parents, no one has ever seen formal charges or who even identified him so he can start saying, oh, no, that person was in jail, or I never saw that person at the concert, or talk to these other people who were at the concert. They didn't see this person at the concert. I think that person lied on me because I had beef with that person 6 months ago. I mean, we can't do anything. So think about the trouble that you get yourself into and how difficult it is to get out. Because if this case goes to trial, it might be 2 years before it goes to trial.
And that's a very good point, Vivian. Once you get into trouble, it's so hard to get out of it. And Patrick and Pius, let me say this. This is an allegation at this point. It's just a criminal information, an allegation. You know, your nephew is presumed to be innocent. And I want you to know that he carries that all the way through trial up until the time that the state presents their witnesses to overcome that presumption. But what I said earlier is that you need to be very patient, because Vivian is absolutely right. This case could take a very long time to resolve. Don't think about what the government might do in a case like that, but the statute calls for the charge of capital murder where 2 or more people are killed in the same criminal episode.
Right. And there are many ways that you can be charged with capital murder, and this is one of them. Since 3 people were killed, that's 2 or more, and so that's capital murder. So there are two punishment options in a capital murder case. The government can seek the death penalty, which the choice would be life or death, and the jury has to answer 3 special issues. Or they can, there's a committee in the DA's office that looks at the person's criminal history, the manner in which the murders occurred, to determine whether they think this person will basically be a continuing threat to society and basically cannot be trusted and we need to kill them. But there are 3 specific special issues that have to be answered by a jury. Or they can say, we're not going to seek the death penalty, and that's called a non-death capital murder. And in those cases, after the jury, if the jury convicts you and finds you guilty, then you automatically get life. And right now it's life without parole. That's complicated because I follow the law, and if I become judge, I will certainly follow the law. But I do have mixed emotions about a law that says that every kind of case we have a 2-phase trial, a guilt, innocence, and a punishment phase. But in non-death capital murders, there's no punishment phase. Tell me how you feel about that, Ricardo.
I've always had mixed emotions about that. As you all know, I tried a lot of non-death capital cases where once they find the defendant guilty, that he engaged in that conduct intentionally. And typically there were cases where the background of the defendant did not warrant their consideration for the death penalty, or there was something good in his background, or there was a lack of criminal history. And as you will put it, Vivian, that goes to a special committee. And I believe that the DA herself, Judge Patricia Likos, will be there, as well as the first assistant, and they'll have a little powwow, so to speak, and they'll decide whether or not a particular person should get the death penalty or not. So it's early in the ballgame in this case. We don't know what's going to happen, but those decisions will probably be made down the road. It could be in the next month. It could be 2 months. So we told the family they need to be real patient, and I keep saying that, but that's the way our system works, and I believe that those decisions will be made probably sooner than later.
Do you have any other questions about this, Pius?
No.
Not now? Okay. Patrick, do you have a question?
I don't have.
You don't have a question at this time. Okay, well, as we were reading in the paper, it says witnesses later identified Uvakanzi in a photo lineup as the trigger man. Now let me talk about that. What bothers me a lot of times in cases is that apparently someone has talked to the press. So the police and the DA's office is very willing to talk to the press, but they won't even talk to his own defense lawyer. If you have any thoughts about that while you're watching, give us a call back at 713-807-1794. How do you feel about that, Ricardo? Now, the paper, some person who just writes for the paper has all of this information, but yet I have none. And I have to rely, as his constitutional lawyer, constitutionally mandated lawyer, I don't even have what a reporter had.
That tells me that someone in the DA's office spoke to this reporter and gave him bits and pieces, enough for him to
write a 2-page article.
Write a 2-page article, exactly. So I don't know. I just, like I said earlier, Vivian, I just think it's somewhat strange. Normally they would show up with a police report, or they would at least give you maybe the gems, a paragraph or two, or something. Yeah. And so apparently the writer here for the Chronicle had enough to go on to write this article. And my question is, has he written subsequent articles, or is this the only one that's appeared?
Family, this is the only one, isn't it?
No, they have so many articles, but different newspapers.
So different newspapers, but they all wrote around the same time about the same case. So the information is still the same. Nothing different, right?
There are not difference. But you just the same thing, but some wrote something that is wider, bigger than the others.
Okay.
Some are just very few information that was here. Some gave details information. From
any other details that were not read here? Any other details?
I think this one is very comprehensive.
So this one has the most details.
Exactly.
Okay. So one of the things that you'd be curious about is, since the artist that gave the concert was shot, you would wonder if some of the motive has to do with him. You know, there's someone named Trey the Truth that got shot, and people around him that got shot. So you'd wonder if this is a killing or shooting related to beef between one artist and another artist, or was the artist really the target of the murder?
Based on the context of the article, Vivian, it appears it's clearly an ongoing investigation. It is going to be a very convoluted. Right now, the facts are not real clear as to who saw what, and you have bits and pieces, and that just makes your job a lot harder.
Sometimes I wonder if the police don't rush to judgment, because as we all know that you have forever to indict someone. And I understand there is a balance that if this person did it, get them off the street. But then there's also that thing that a lot of times when people commit murders, they kind of cool out, they chill, they admit it to their grandmother, they go to confession. To me, sometimes the police, they're too fast. You could say if they developed him as a suspect, they could have still just had him as a suspect and still interviewed people. Give it 6 months. Give it the time that you're holding him in jail to see if people talk, if things change. Sometimes I think that they rush to judgment. What do you think?
And I agree with you wholeheartedly. Look what's happened over the course of the last 10 to 15 years in the state of Texas, where people have been on death row and they've come within minutes of being executed, later to be acquitted, where it was clear that the prosecutor, the police rushed to judgment, or they focused just on one person and eliminated everybody else. And then we found out later that these people were actually innocent.
And that's what troubles me, is once a reporter puts something out like this, the DA's office now is going to try to make this be what the case is. And this could be from, like I said earlier, people who had third and fourth hand information, because the actual people might not want, because I think that they have probably talked to people who said they weren't there, who were actually there. So a lot of times when people are in this life, this nightlife, and they see things, they're not forthcoming in what they saw. So a lot of times the people who do say they saw it or they heard about it have it all wrong. And so that's the thing that's real frustrating to me, is that we don't have a society in which the police might make a mistake and they won't admit it. They stick to some facts and they just try to keep controlling everything until it fits into this puzzle that they've created, instead of admitting the fact that we just really don't know who did this and we need to keep investigating this case.
Right, and like I said earlier, it's an ongoing investigation. They're talking to as many witnesses that are willing to come forward, and it's clear probably that a lot of witnesses did leave the scene. They did not want to be a part of it, and maybe some of those witnesses did see something. So we just don't know at this point.
Right.
But I think the sooner that the prosecutor allows you to see the file, the sooner you can start your investigation. In the meantime, what you can do at this point is talk to your client and reassure them that it's a lengthy process and it's going to take some time to resolve this case.
Okay, well, another comment that I want to make is, how do you, in your extensive 27-year career, reassure families? Because when they pay you, they want some answers right now.
They're so results-oriented, aren't they?
Everybody's so results-oriented.
Yeah. It's a good start to get the family in and encourage all the family members to come to your office to talk to them and start talking to them and explain to them the process. A lot of people don't understand the criminal justice system and how it works. But bring as many family members that are willing to come forward and get a feel about who your client really is. Sometimes your client doesn't want to come forward and tell you everything he's done, the good, the bad, and the ugly. So you need family members. You want to encourage them to come forward, talk to them, and have your mitigation specialist there.
And let's talk about that. Now, we've been saying mitigation, and some of my viewers might not understand that term. One interpretation of that term is, what makes you less blameworthy? What evidence is there that either you didn't do it or you're not as culpable or responsible? You're not the person that should be put to death, because there are things and factors that have occurred in your life that make you not as responsible for your actions and your negative conduct as some other people. So, for example, if you've always been raised by two parents, gone to good schools, gone to church every Sunday, you might be more blameworthy if you go out and kill 3 people. But if you had no family support, you were in foster care, you are borderline retarded, you were always in special ed, people always picked on you, and you always were fighting, or you were raped as a child, you were abused as a child, so all you know is to distrust people, and you have a lot of anger, where you have anger management issues, that might make you less blameworthy if you've had the bad environment as opposed to the person who was raised in the good environment. So that makes you less blameworthy or less less likely, or someone society shouldn't punish to the fullest extent of the law, which means take your life. You've already had a bad life, so we're not going to kill you. We're just going to keep you in jail for the rest of your life. Do you want to comment on that, Ricardo?
Right. Mitigation, of course, only plays a role after you've been charged with capital murder, you've been convicted of capital murder, and the state clearly is seeking the death penalty. Then you get that in the form of a special issue. Mitigation can be anything that lessens your blameworthiness, as you very eloquently stated, and it can come from either side. Youth could be a possibly mitigating circumstance.
Certainly.
He's 18 years old, because we know 17-year-olds are not subject to the death penalty in the state of Texas, but an 18-year-old, youth could play a factor where one juror can say, I think his youth is sufficiently mitigating, and I don't think he should get the death penalty. So mitigation could come from his background, where he grew up, as you stated earlier, the things in his life. Was he abused as a child? Was he whipped by the mom? Was he denied food? And there's just a myriad of things that could be mitigating. What could be mitigating to one person might be militating to another juror. So you have to be real careful, but it's important that if they seek death and you do individual voir dire, you want to make sure that the juror understands mitigation and what it stands for.
And exactly, and a typical team in a death penalty case, which costs a lot more money for the state and for the defense, is that you have two lawyers. You usually have a first chair and a second chair, which split the duties. You have a mitigation specialist, and that's someone that has a master's degree and an investigation license through the state of Texas. Because what they typically do is subpoena all of the child's school records, any hospital records, were they ever hospitalized, did they have a head injury, anything that could have happened to affect their growth and development or their rationalization of facts and their thought processes. So a mitigation specialist has taken classes in trying to figure out what makes a person tick. An investigator has an investigation license, so that's the fourth person on your team, and they're supposed to investigate the facts, the guilt, innocence facts, or just talk to people. And the reason why you want an investigator in a case is because if I go talk to them alone, I can't be the lawyer and the witness. But an investigator can be a witness if need be. If the person changes their story, if the person disappears, and they can come in and say, no, I was there with you, with Ms. King, and this is what the person told me. So that's why we always have to have investigators. Plus, that's their job to investigate. So while I'm working 8 to 5 and I'm in the courthouse, they're out hunting for witnesses and hunting records. So there are at least 4 people on your team. But generally, in a death penalty case, there's going to be, the government is going to, we're going to have psychologists involved. We usually have our clients tested to see what their brain capacity is, their psychological capacities are. We sometimes have a death penalty expert. The government will have one to say, because of this client's factors, this defendant's factors, we believe that he's a continuing threat to society, even in prison society. So he's not worthy of living even in prison for the rest of his life. We need to kill him. So then we have to have an expert on the other side that says, no, those factors are wrong. Your factors, to rebut whatever the government says. Because, you know, in any time there's a psychological analysis of things, there's always 2 sides to that story. But let me tell you what's real important, I think, in this case. In this particular case, what do you think what college, y'all not calling me tonight, so I can't ask, but to me, we need an identification expert. Obviously, there's going to be a problem, because at 3 in the morning after a club with a rap concert, I'm going to expect that most of the people out there are either high off some kind of drugs, illegal drugs, cocaine, crack, PCP, pills, alcohol for sure, if the place serves alcohol. So it's dark outside, it's a parking lot. So we are going to have to evaluate what factors affect a person's memory and sight and thought processes. What do you say about that, Ricardo?
Well, one time in the 174th, but not this current judge, I gave notice to the state that I had an identification expert, and the visiting judge denied it. He says, I'm not going to let that expert testify. Wow. It was an on-death case. It was in a capital murder. But I think because this is capital murder, I don't see why they would deny you that, because, you know, there's 5 factors.
Right.
Did the person observe what they really observed? Were they in a position to observe? How dark was it out there? And all of those factors. So clearly that is going to be the focus of your investigation. Who saw what, and were they intoxicated?
Right.
And were these people contacted later? Had they left the scene, or did they stay at the scene? So all of that's very critical. And I think that that the judge knows the law well enough that he won't deny you that identification. I think as long as you show a need for it, and it's very critical in this case because the article seems to suggest that that's what they have is eyewitnesses. And then they put the defendant in a lineup and he was subsequently identified according to the news article.
So what's going to be real important is how close were they to this person? Why didn't they stay at the scene and tell the police? Why did they come forward and tell the police voluntarily, or did the police have to go out and find them? Did they have a motive to lie? Those are the things that we have to look into. Were they close to the person? Were they someone that almost got shot too? Because it sounds like bullets, were the bullets all concentrated in one area where these 5 people got shot? Or were they randomly, were the people all over the parking lot and bullets were flying everywhere? So all of those things are going to be important factors in a jury deciding beyond a reasonable doubt whether or not this person did this.
Right. And earlier, Vivian, you talked about the government's role. Believe me, when they seek the death penalty against the defendant, they will go way out of their way to pull all their school records. Believe me, they will find the times that you talked back to a teacher or that you were a bully and maybe pushed another student to the ground. They will bring that evidence to show that you are a future danger. You are a bad character. And irrespective of what mitigation or what might have happened in your life, look at all these bad things. And they will find it, and they will do just a thorough investigation. So, and I don't have to tell you this. I know you'll be prepared for that.
Tell the juror. Tell our listeners, because they're learning.
Right. Well, when the state seeks death, number one, they think he's a good candidate. It went to the committee. The committee said, we all are unanimous, and we agree that this is an excellent candidate for the death penalty. The crime is heinous in and of itself. And the law says that the crime in and of itself could answer the first question, special issue. And of course, that has a burden of proof for the state. Do you find from the evidence beyond a reasonable doubt that he's going to be a continuing danger to society? And it talks about prison society too.
Right.
And we may think that that's the boring aspect of it, but that's when you win capital murder cases.
Yes, that is.
When you go into the voir dire and you go into a person's head, and you have a head start, and it's great that we do the questionnaires. I think that's a wonderful thing to do. You find out everything about how people feel about the death penalty.
Exactly.
And people's opinions and attitudes have changed through the years, as you all know, with the advent now of life without parole. Some people tend to lean on, well, I'm going to lean on the side of caution and maybe just save his life and find mitigation or find that the state has not proven their case beyond a reasonable doubt with regard to future dangerousness. So in that aspect, it's just a lengthy process, but you learn so much from that juror because you could take a break and go to lunch and come back and know that they've changed their position. They maybe are not as strong as they were on paper.
Right.
Yeah. So I think it's very critical, and we don't want to speculate. We don't know what the state's going to do in this case.
Right.
But if they do proceed to that because the crime is vicious and violent and they think they have the right person, then I know that you'll be prepared, and voir dire is a very, very critical aspect of a capital murder case.
Explain to my viewers what voir dire is.
Yeah, voir dire literally means, it's a French term, to literally speak the truth, where the prospective jurors are told, look, there's no right or wrong answer here. We just want to know how you feel. You're not going to shock us. You're not going to surprise us. If you feel that you cannot consider the death penalty under any circumstance, well, guess what? You're not going to be on the jury.
It's true.
There's a case called Witherspoon versus United States, and when the judge Witherspoon's the prospective juror, that simply is for the court to find out that they're willing to consider the death penalty.
And we call that death qualified.
That's exactly right. And once they become disqualified because they're willing to consider it, then you delve a lot deeper than that. And the questionnaires are very lengthy and very thorough.
And it's a very long lesson for us to try to teach in the next 5 minutes. But one of the things I want you to know and to take from this, if you hear lawyers talking about death qualified, that means that they can consider the death penalty. So everybody, every juror on a death penalty case is death qualified, which some people think is not fair. So that means, from us defense lawyers, is that they're all killers. They're all a person that says, I can kill someone under the right circumstances. Right. And so all 12 people are going to be killers. So it's just a matter of, are they going to kill you in this case?
That's exactly right.
If they say that they can't kill you or they can't consider the death penalty, then they cannot be on the jury in a death penalty case. And so therefore, there's a lot more litigation, and it's a lot more expensive when they want to seek death versus if they don't seek death, if it's non-death. But we have 5 minutes, so if the family wants to say anything as to what you're going through or any questions you have, I want to take this opportunity to thank you for having the courage to come on and talk about and let us talk about your loved one's pending case. I will, if my viewers are interested, I will keep them informed. Your relative did want me to talk about his case. He thinks he's being treated unfairly. He says he's not guilty. The facts will develop as they develop. Do you have any comments or questions that you want to leave my viewers with?
Just like I said before, I say my nephew was not guilty of the said offense. And invariably, he was not given fair hearing, like the way I believe he should be given a freedom of expression, for him to, defend himself. Like I said, they said eyewitness. That is a serious matter. They said anonymous call and made to the police. These are the issues I want to trash out because, as a matter of fact, an issue that will involve a captive mother will not be something the government should take very lightly.
Right.
That they will rely on such hearsay evidence,
right,
which is the wicked evidence in a matter like this. So I expect them to revisit this matter very critically with the way the government is going about it by putting restrictions on some of the information that we are going to use to defend this matter. My cousin came all the way from West Germany because of this matter. The family sent him to come here with us and see things by himself. And he have interviewed my nephew too, and he maintained the same. And that is the family's stand, that my nephew did not commit the said or the alleged offense. And the government
we have
should
1 minute, so let me stop you. Patrick, do you want to say anything? Pius is saying you came all the way from Germany to represent the family, to try to get a better understanding so that you can tell your international relatives, international family about it.
Yeah.
And you're disappointed in the way the system is working, is that right?
Yeah, I'm disappointed in the way the system is working in America, but all the same thing. I hold the opinion that an English word said, justice delayed is justice denied. I believe they should fasten up everything and give you every right to go into the case. The faster case goes is the faster the truth comes out. So I believe let them go into the case as fast as they can.
Okay, and we have 30 seconds. I just want to ask you, do you know what a death certificate says when the government kills someone? What do you think it says, Patrick?
Death certificate to kill.
What do you think it says, Pius?
Say it again.
What do you say? The death certificate, when the government kills someone, says homicide on it. And I find that to be very interesting that the government has killed someone. It basically says that they murdered the person. Yeah. We're going to wrap up this episode of Truth and Justice with Vivian King. Remember, I want to tell your story. So call me at 713-222-2019. Add to the conversation. This is your community. You should understand how the criminal justice system works here. And I'm here to tell your story every Wednesday night from 6:30 to 7:30. Thank you for watching, and I hope you've been enlightened by this very heavy-hearted but serious crime. And God bless the families of those who have died. God bless you and good night. Thank you for tuning in again. Tonight we have something really good, a hot topic in the news this week. He's been charged with a crime. This is a show where I try to educate real stories.